Welcome back to the daily Rambam class. We are up to the laws of Shavuos, chapter 10. But as it is Thursday, let's start with a quick check-in where we're up to in the Rambam. We are in the 6th volume called Sefer Hafla'ah, which is translated here as promises. It includes promises and oaths and vows. There's actually 4 sections in this book, totaling 43 chapters. The first 12 chapters are about Shavuos, oaths, which we're learning about now. The 4 types of oaths. And then the next 13 chapters deal with the Darim, which are more like vows. Then the Nazirus, which deals with the Nazarite. And Arachan and Charabim are finally gifts that a person makes to the Beis Hamikdash. In the first section of Shavuos, which are oaths, as I said, there are 12 chapters. And today we are already up to chapter number 10. So over the next 3 days, Thursday, Friday, Shabbos, by the end of this week, we will conclude the first section of the subject of Shavuos, oaths, and then we'll move on to the Darim, which are types of vows. So looking at oaths, these 12 chapters, this is my synopsis of what we were covering in these 12 chapters. We spoke about 4 types of oaths, how to make an oath, invalid oaths, different wording, and then we work through the 4 types of oaths. The first type is Shvuas Bitoy, which is, I think, where a person says he will do something and he does not carry through. Then Shvuas Shav is, I think, where a person says something which isn't the case. So he says it's day when it's really night. And then we spoke about annulling oaths. And then the other 2 types of oaths are Shvuas HaPikadon, which is where a person takes an oath regarding an article that was entrusted to him. And the 4th type of oath is a Shvuas HaEdus, an oath of testimony, which is what we started learning about yesterday. We will continue learning about today and conclude learning about tomorrow. And then the final and 12th chapter will give us a few words on the importance of how careful we need to be about our oaths. So let's take a look at today's chapter, which is chapter 10. I have over here invalid oaths. That's actually a mistake. That's from last week. But we are up to, other than that, all the information there should be correct. So we'll run through the halachas on the right. And if you want to just take a check-in on the left-hand side, then you'll see in summary the topics that are discussed in today's chapter. And in the message I sent out, I spoke about pleading the 5th. So we'll see how that comes up when it comes to oaths of testimony. So a person is liable for a Shvuas HaEdus, meaning a person is liable for violating the negative mitzvah regarding Shvuas HaEdus if a person swears that he does not have any information when really he does. But that was actually not 100% accurate. More accurately, when a person swears that he doesn't have testimony to share, testimony that to share that will be of financial relevance when really he does. So as far as the question, can you plead the 5th, from a Torah perspective, when it comes to having testimony to share, you actually are not allowed to plead the 5th. If you have testimony to share, then and you are asked, then a person may actually say, can place an oath on you. A person could say to you, I know that you have testimony to share. I know that you witnessed this transaction. And if you're denying it, then I'm placing an oath on you, even if you don't take the oath. If the other person says, so let's just give a practical example. I don't know, let's say Discovery gave a loan to whatever company to Pick and Pay, and now Pick and Pay is denying the loan that it took from Discovery, and now Discovery comes to me and says, Rabbi Yosef Chazdan, you were there when we gave the loan. Please will you come and testify in court that Pick and Pay owes us the money? I said, what are you talking about? I can't just plead the fifth. I can't just say, no, I don't feel like sharing. If I was actually there when that loan took place, if I actually witnessed the transaction, then I have an obligation to testify in court. So pleading the fifth is wonderful in certain situations, but when it comes to having testimony to share, that is of financial relevance, a person is obligated to share it. Okay, every rule has its exceptions, but that's the rule. So then Discovery can actually put the oath on me. Discovery can say, we hereby, I mean, we looked at the wording in earlier chapters, so it's not exactly like this, but approximately Discovery can say, we hereby place an oath on you that you have no information. And if I answer Amen or yes, then it means I've just taken an oath. If I don't have any information, that's fine. If I do have information, then not only have I lied, I have just violated one of the 630 mitzvahs, which is what we're speaking about over here, an oath of denial of information that I actually have. In fact, as we'll learn soon, if this took place in a court, even if I didn't say anything, the court can place an oath on me, and it's binding. So it's interesting, without saying a word, if it's in court, then they can place an oath on me, and if I have information and I'm not sharing it, then I will be considered to have violated the oath by just hearing the oath, even without responding. Today's chapter, chapter 10, discusses scenarios when I would not be liable for this transgression. And the first scenarios it discusses are scenarios where, had I come forth and told the truth, so really I did witness it, right? Let's say I was there and I witnessed when Discovery gave the loan to Pick and Pay. I saw it happening. However, I'm a brother of the owner of Discovery. And therefore, had I given that testimony, it would not have been valid because I'm a relative. Or perhaps if I've sinned in a way that disqualifies me from giving any testimony. So in all these scenarios, although I'm lying by saying that I don't have information, or by not admitting that I have information, have I lied? Yes. In fact, have I even violated an oath? Perhaps, because if I say that I swear that I have no information, then I would have violated one of the other two types of oaths, maybe a shvuas bitoy, where you say something that's not true, or shvuas sham, forgot which one's which. But I would not have violated having made an oath about testimony. Because in order to violate that mitzvah, it needs to be testimony which is of monetary weight. Meaning, had I testified, it would have had monetary consequences. Okay, if I've lost you, let me simplify everything I've just said to the best of my ability. What we're saying in the first halacha, we'll look at it now inside, is that if I have testimony to share, which is not of financial weight, and I swear that I don't have testimony to share, even though I do, I will not have violated the violation of oaths of testimony. Why? Because But had I given a testimony, it wouldn't have been of significance. Let's see that inside. But if both or one of the plaintiff's witnesses was unacceptable, a relative, or even one of those disqualified from testifying by rabbinic decree, like somebody who gambles by profession, or a king who is not fit to give testimony, and one of the two witnesses was such a person, or alternatively, if the witness heard the testimony from another witness. So if I say, okay, I wasn't there when Discovery gave the loan to Pick and Pay, not that it ever happened. I'm just making up an example with companies that most of us are familiar with. But if I wasn't there when it happened, but I heard from a good friend and he was there, okay, so although they both denied knowing testimony and took an oath, they are not liable for shvuas ha'edus, for an oath of testimony, because had I testified, it would not have obligated Pick and Pay to pay Discovery. Why? Because I'm a relative, or I'm a king, or I'm disqualified, or I didn't see it myself, I only heard it. So that was invalid testimony that was denied. I denied having testimony which I would be invalid to give. The next four halachas deal with it wasn't invalid testimony, but it didn't have monetary weight. For example, if the plaintiff said, I am administering an oath to you that you come and testify on my behalf, so that so-and-so, what's the testimony? That so-and-so promised to give me 200 zuz. Okay? You were in shul that morning when we called the guy up for an aliyah, and he said, I promise that I will give the Great Park Synagogue $1 million. So come and testify in court. You were a witness. You saw he made that promise. I said, I don't know what you're talking about. I never saw such a thing. And I'm lying because I wasn't sure, but I heard him say it loud and clear. So, and an oath was placed on me. I'm not liable for shvuas ha'edus. Why? For even if I would testify concerning the matter, this would not require Yankel Shmerel to pay Great Park $1 million. Why? Because legally, when a person makes a promise that he will give, it doesn't yet cause the money to belong to Great Park. So if a person says, I will give $1 million to Great Park, has he not kept to his words? He hasn't kept to his words. But is he financially now indebted to Great Park? Not at all. If a person said, I have just given $1 million, as we'll learn about then, so then it would be legally binding, because he would basically be saying that money that's in his hands no longer belongs to him, it belongs to Great Park. But if a person says he will give, as in a pledge, that doesn't have financial weight. It has other ramifications, but not financial weight. Therefore, if I denied having such knowledge of such an experience, I wasn't sure that I say that I wasn't, or I heard and I say that I didn't, then although I was taken to oath by this, I would not be liable for shvuas ha'pikadon. Similar laws apply to all similar situations. Another scenario: if I charge witnesses with testifying that he was a priest or a Levite, or that he was not the son of a woman who underwent divorce or chalitza, right? If a kohen marries a divorcee, then the child loses his status as kohen. He's a chalal. So I'm asked to go and appear in Beis Din to testify that Yankel is actually a kohen. And I know it because I saw his father getting called up for going up to Duchon or whatever it was. I have good testimony that Yankel is a kohen. And so I'm asked, I said, I have no information about Yankel. It's like, but you do. Of course you know his father. You saw his father being going up to give the priestly blessings. Don't know what you're talking about. Take an oath. An oath is placed on me. If I were to lie and take such an oath, then I would not be liable for shvuas ha'edus, because it's not a financial claim. I am withholding testimony inappropriately, but it's not of financial significance. It rather just means that now Yankel is not able to get called up for kohen, or he's not able to duchen, or give whatever else. Now, what about if Yaakov wants to receive the 5 coins? That's financially significant. Only a Kohen can receive the 5 coins of redemption of the firstborn. So we'll see in the next few halachas, that's not called financial. It's consequential. And this halacha of violating, swearing that you don't have information is not when the information can lead to financial consequences, but when the actual information is a piece of information, it's a testimony that itself has financial direct ramifications, not just not indirect consequences. Similarly, although the witness denied knowledge of the matter and took an oath, they are not liable for the shvuas ha'etos if the plaintiff charges them with testifying with regard to the following: his son inflicted a wound upon him, okay, or so and so kindled his grain heap on Shabbos, or so and so raped or seduced his virgin daughter who had been consecrated. She was married already. So in all these scenarios, there is financial consequence, but there's more than just financial consequences. There's actually capital consequences. The rationale is that if they were to give the testimony, the defendant would be liable for execution by the courts, and not for making financial recompense, as we explained in Hilchos Naira. Similarly, laws apply in all the negative situations. So if I could give testimony that would require the person I'm giving testimony against not just financially, but actually for his life. So we've learned when a person needs to give his life, when the person is deserving of the death penalty, he doesn't both pay and give up his life. Once he has the death penalty, then that's the only punishment that's given him. So since my testimony would not have had financial consequence, it would have had more than financial consequence, but not financial consequence, I wouldn't be violating this mitzvah. Halacha number 5. If there was only one witness and he denied knowledge of a financial claim. So discovery came to me and said, you were there when we lent money to Pick and Pay. Come and testify in court. And I say, what are you talking about? I don't know what you're talking about. And he said, we place an oath on you. Swear that you don't have any information. Or we place an oath on you that you don't have any information. And I took such an oath. And really, I did have information. Since I'm only one guy, I wouldn't be liable of this mitzvah, of violating this mitzvah. Why? Because one witness is of no financial consequence. Unless he is, as we'll see in the next few halachas. But before we get there, now let's talk about promiscuous testimony. Okay? So, if one charges 2 witnesses with testifying that his wife committed adultery, and they deny knowledge of the matter, and they took an oath to that effect, they are liable for shvuas ha'etos. Why? For had they testified, they would have caused her to forfeit her ksuva. And since a ksuva is a financial right that a wife gets from her husband if he divorces her, once a woman commits adultery, she loses her right to the ksuba. So had I testified that she committed adultery, I would have caused the husband to be absolved of paying up a ksuba. So therefore, that is financial, and I would have violated this mitzvah. Okay, more about that. If a husband charges witnesses who observed him administering a sota warning, so a person gave a warning to his wife, he saw that she was up to trouble, and he says, I warn you, you should not be in seclusion with this and this guy. And he did so in the presence of witnesses. Or those who observed her entering into privacy with the man concerning whom she was warned. So either the witnesses saw me warning my wife, or they saw my wife going into seclusion. Not my wife, but the person's wife. And they denied the knowledge of the matter and took an oath to that effect. They're not liable for shvuas ha'etos. Why? Because even had they given testimony that I had indeed warned my wife, or she had indeed been in seclusion with that person, she still has the option to drink the sota water. And if she drinks the sota water and she's innocent, then nothing will happen to her, and she'll be allowed to once again be with her husband. So not necessarily is there any financial consequences over here. True, if she refuses to drink the sota water, then she loses her ksuva. But that's already one step removed. That's if she decides to refuse. There isn't immediate financial consequences of this testimony that I denied to give. Halacha number 8. A witness is liable for shvuas ha'edus if a man issued a certain warning to his wife, she entered into privacy in the presence of 2 witnesses and committed adultery in the presence of 1 witness after being warned and entering into privacy. If the husband administered an oath to this witness that he come and testify that he denied, and he testified that he denies knowledge of the matter, this witness is liable. Why? Although he's only 1 witness, we've learned that specifically with regards to the Saita woman, once a woman has already been warned in the presence of, and been in seclusion in the presence of witnesses, that if even 1 witness says that she committed adultery, she already loses her right to the ksuva. And so this is an exception where 1 witness is actually able to give testimony that will have financial consequences. And he continues to give in the next 3 halachas other examples of where 1 witness can give testimony that has financial consequences, and therefore if he denies knowing that testimony, he would be liable for shvuas ha'edus, for an false oath of not knowing, having testimony. Similarly, in any other instance where the testimony of 1 witness creates a financial obligation, if that witness denies knowledge of the matter and took an oath, or an oath was administered to him in court supporting his denial, he is liable for shvuas ha'edus. For example, what is implied? So here's some examples. If both the plaintiff and the defendant were reputed to take false oaths, meaning this person has a reputation that he lies, that he gives false oaths, not just lies, but he gives false oaths. And so such a person would not be given the opportunity to take an oath. The plaintiff administered an oath to 1 witness that he should come and testify that so-and-so owes him a mana, 100 of something. And he denied knowledge of the matter. He is liable for shvuas ha'edus. Why? For were he to have testified, the defendant would have been required to pay because of his testimony, as will be explained in Hilchos Tayin. Similar laws apply in other similar situations. So let me explain what this means. What that means, practically speaking, is if discovery goes to Pick and Pay, and they come with 1 witness, they drag me along, and I testify that I saw discovery giving Pick and Pay a loan. So 1 witness does not require Pick and Pay to pay up the loan. Only 2 witnesses would require Pick and Pay to pay up the loan. However, 1 witness can require Pick and Pay to swear that it's not true. So 1 witness does require the defendant to have to take an oath in denial of the 1 witness. Once it's 2 witnesses, then that's legally binding. If it's 1 witness, the defendant can challenge the witness with an oath. But if the defendants, in this example, were Pick and Pay, and this is not true, but were they have to have had a reputation that they are not reliable with oaths, then the moment 1 witness would require Pick and Pay to take an oath, they wouldn't be able to take an oath, and so they'd have to pay up. So in such a scenario, when the defendant is unable to take an oath, then 1 witness would require him to pay, and when that witness denies having the information that he does, he would be liable for shvuas ha'pikadon. When a woman administers an oath to 1 witness that he testify regarding the death of her husband, and he denies knowledge of it, he's liable for shvuas ha'edus, for an oath of testimony. Why? Had he testified, she would have been able to remarry and receive her ksuva. So that's financial, it's the ksuva. Since it has financial consequences, although it's 1 witness is believed to allow a marry to remarry, meaning 1 witness that witnesses a man's death already frees the woman to be able to receive a ksuva from his heirs and to remarry. When does the bab apply? When she could have collected the money due her by virtue of a ksuva only from movable property. If, however, she could only have collected her ksuva from land, then the witness is not liable, because we've already given a principle, I think yesterday, that the concept of an oath of testimony does not apply to land. This also applies if there are 2 witnesses, for when 1 administers an oath involving landed property, they are not liable, as we explained. So that's regarding denying land testimony. If a person denies having testimony for land, although he's lying and it's bad, he wouldn't be liable for the particular sin of violating an oath of testimony. It would maybe be violating an oath, but not an oath of testimony. Okay. So here's an interesting scenario. 2 witnesses were called up to give testimony, which they had, but they denied it. Okay. So if they denied it together, then obviously they'll be liable, because had they testified, the person would have had to pay. So by them lying that they don't have, by them trying to plead the 5th in a place where they're not allowed to, so they would be liable for the Shvuah Sa'edus. But here, we're going to look at when the 2 witnesses didn't speak up at once. And since they didn't speak up at once, it means that one of the 2 already, his statements were not of financial consequences. Let's see that inside. When a person administers an oath to witnesses in court, and both deny knowledge of the matter at once, meaning the second the witness began his denial immediately after the statement of his colleague. The second witness began his denial immediately after the statements of his colleagues. So one witness denied having information, and then the second witness denied having information right after the first. So then they're both liable for the Shvuah Sa'edus. Each one of them must bring a sin offering for his oath. But if the first one denied knowledge of the matter, and the second witness waited longer than the appointed time period and then denied knowledge of the matter, so the first witness is liable for Shvuah Sa'edus, because had he testified at that point, it could be that the other witness would have also testified, and then it would have been financially binding. And so by him denying information that was financially binding, he's liable to bring an offering. But the second is exempt. Why? Because once the first guy denied having any testimony in court, and the second guy waited a bit, at this point, even if the second guy would give testimony, it would no longer be financially consequential, because he's a single guy. And so the second guy would be exempt from a Shvuah Sa'edus, from having to bring an offering. Okay? If one of the witnesses acknowledges the claim, he says, yes, it's true, I testify, Pick and Pay did take a loan from Discovery. And the other denied, so the one who denied is liable, is very liable, because had he admitted, he would have caused Pick and Pay to have to pay back the loan. The fact that he denied is very financially consequential. Regardless of whether he made his denial before or after the first witness. But if they both denied knowledge of the matter at the same time, and then one took the initiative and acknowledged the matter immediately thereafter, so he says, I have no information. Actually, one of the guys, so the 2 of them together say, we have no information. And then the first guy immediately retracts. He says, to be honest, I do have information. I was there. I saw the loan. Here are the details. So the one that admitted is obviously exempt because he's now actually giving the testimony. But the witness that persists in his denial would be liable, because at this point he's preventing Pick and Pay from being liable, because there's right now only one witness instead of 2. Okay. Now when you have 2 sets of witnesses that deny. So here's an interesting one. If there's 2 sets of witnesses that are both testifying that Pick and Pay borrowed money from Discovery, and the first set of witnesses deny information, they actually won't be liable. Why? For Shvuah Sa'edus. Why? Because they're not causing Discovery to suffer a loss, because there's still a second set of testimony, a second set of witnesses that can still testify. So as long as there's still other sources of information via which Discovery will be able to claim their loan back, it means that this witness isn't the make it or break it guy, or this set of witnesses isn't the make it or break it team. And therefore, their denial would not be financially relevant, and therefore they would not have to bring a carbon. I see we've run out of time. Let's wrap this up quickly. When a person administered an oath to 2 pairs of witnesses who are both fit to deliver testimony, and the first group denied knowledge of the matter, and then the second pair denied knowledge of the matter, the first are not liable for Shvuah Sa'edus, because they're relying on the testimony of the second pair. And that testimony is sufficient to expropriate money. Hence, the defendant would not be liable to make financial restitution because of the testimony of these witnesses who denied knowledge of the matter alone. But if the second pair of witnesses were related to the plaintiff or to the defendant by marriage, and their wives were on their deathbeds, then the first pair of witnesses are liable. Why? But at the time the first pair made their denial, the second pair were not fit to give testimony, even though they soon will be. Okay, so here's an interesting scenario. You have two sets of witnesses that both witnessed discovery giving the loan to Pick and Pay, but the second set of witnesses are related via their wives, but their wives are about to die in 10 seconds time. Right now their wives are still alive and therefore they're disqualified. The moment their wives die, they'll be fine. But since at the moment they're disqualified, it means right now the only legal testimony we have is the first set. And so the first set, if they deny that information, will be liable. If subsequently the second set's wives die and now they're fit to testify and they deny the information, they'll also be liable. So here's a scenario where you have two sets that are both liable even though they didn't give testimony at the same time, because the second set only became fit witnesses after the first set denied. The final three halachas: multiple denials in and out of court. When the person charges his witnesses with testifying on his behalf and they deny knowledge of the matter, he administers an oath and they answer Amen. And he does so 4 or 5 times. And each time they respond, they say Amen, 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 Amen. And then he brings them into the court. And in court, they acknowledge the matter and testify. So they're not liable for shvus ha'edus because, as we said, this has to be done in court. But if when they came into court, they persisted in their denial, they're not only liable for their denial in court, they're also liable for all their denials outside of court. So they would actually be liable on 6 accounts and have to bring six offerings. When does the Bab apply? When they answered Amen. If, however, they did not answer Amen, but merely denied knowledge of the matter after each oath, so an oath was said to them, but they made no verbal response, then they are not liable unless that happened in court, as we explained. As long as they didn't say Amen and it was outside of court, then they won't be liable on those accounts. If the plaintiff administered an oath to the witnesses in court and they deny knowledge of the matter, and then he administered an oath again 4 or 5 times, they deny knowledge of the matter each time, they are liable only once for a shvus ha'edus. This applies whether the oath was administered in court or outside the court, and even if they answered Amen or took the oath on their own initiative time after time. The rationale is that after they denied knowledge of the matter in court, at this point they won't be able to testify. Once a person says, I have no testimony, he can't come back and say, I do, because he's already sworn that he doesn't. So all the additional accounts, are they lying? Yes. But are they liable for shvus ha'edus? No, because at that point, the testimony would be of no financial consequences. Finally, number 19, it can thus be derived that all the oaths that they take after denying oath of knowledge of the matter in court involve a denial of testimony that would not obligate the defendant financially. In that instance, the witnesses are not liable for shvus ha'edus, but they are liable for shvus bitoi, because they've still taken an oath which is false, as we explained.